Welcome back. Now it's time for our last presentation of the morning. Internet retailers and the sales and use tax.
Good morning and welcome to the final segment of the day. My name is Laura Stanley. I'm the Division Counsel for the Sales and Use Tax. I'm here with Steve Russell. Steve Russell is the Assistant Administrator of the Business Tax Division. He focuses mostly on sales and use tax as well. Today we're going to talk about some of the basics of consumer's use tax. Next we're going to talk about the differences between a vendor and a seller. We're going to focus a little bit of time on the seller's use tax and how Ohio and other states establish that substantial nexus in order to collect and remit or require collection and remission. We're also going to talk about responsibilities and resources that Ohio vendors have that sell through the internet. We're also going to talk a little bit about Streamlined Sales and Use Tax Project, federal legislation that discusses economic presence or even physical presence. We're going to talk about Ohio's response to Nexus Landscape after the Wayfair decision earlier this year. Steve?
All right, very good. Thanks, Laura. Whenever we get in front of a sales tax audience, we always kind of like to touch on consumer's use tax. You know, what is consumer's use tax and why do we owe it? The consumer's use tax statutes are in 5741 of the Ohio Revised Code. The sales tax statute of 5739 kind of gets all the glory of sales tax. It's got the exemptions and it's got the definitions that are so important to sales and use tax law. So consumer's use tax, an excise tax is levied on the storage, use, or other consumption in the state of tangible personal property or the benefit realized in this state of any service provided. A consumer means any person who has purchased tangible personal property or has provided a service for storage, use, or other consumption or benefit in this state. Consumer does not include a person who receives without charge tangible personal property or a service. So if I have a company that is providing items that they are giving away to their potential customers in Ohio. They have maybe a small box of laundry detergent that they send to their potential customers. Those are not sales. The company giving those away are the consumers of those items. So what is taxable? Well, sale and selling include all transactions by which title or possession of tangible personal property is or is to be transferred in Ohio. So I kind of like to look at for tangible personal property, I always like to say it's taxable until proven innocent. So until you have an exemption that fits or exception that fits into that, fits against that transaction, it's taxable. Now services, there are about 20 or 25 of them. They're found in 573901B2 through, I think I should probably actually say B12 now with digital, specified digital products. Tax services are a little bit different. They actually have to be one of the enumerated services in order to be subject to the tax. So the service being provided has to fit into the statute in order for it to be a taxable services. One thing else to point out is that all the use tax applies to the same goods and services that are subject to the sales tax. So consumer's use tax has been around almost since the day of the dawn of the sales tax. It was put into law the year after sales tax back in 1936. So consumer's use tax has been around for over 80 years now. Additionally, what is taxable? Now here's some of the services. Now keep in mind that this is in the kind of internet retailer type scenario that our presentation is going over. One of them is the installation of tangible personal property. You might think tangible personal property, how do I provide that over the internet? Well, one of those ways is through software. Pre-written computer software is defined as tangible personal property. So if a provider of that software is transferring electronically that pre-written computer software, then that would be subject to the sales tax if the software is taxable. Then we have automatic data processing, computer services, and electronic information services. ADP, or automatic data processing, is one of our big services we see in the field of software as a service. Ohio has determined that when you're providing software as a service, it is treated as an automatic data processing service. Electronic information services is acquiring data or placing data into a computer for others to provide or receive. Telecommunication services, private investigation and security services. That's another one you might want to kind of maybe wonder, well, what's that got to do in an electronic environment? Well, we also part of private investigation services are home monitoring services, and those are usually kind of done from a remote location. So if you have remote monitoring services of your home or business for police or fire, those are generally subject to taxation. One of the other ones, we have specified digital products, and those are music downloads, videos, books, ringtones, things like that. Other items taxable to most businesses are office equipment, your computers and your monitors, telephone systems, application software, so items that are pre-written computer software like Microsoft Office, that is an application software subject to the sales tax. Office supplies, cleaning supplies, furniture, business fixtures. Now, business fixtures is somewhat of a complex topic. We could probably talk for a couple hours on business fixtures just alone, but business fixture is an item of tangible personal property that becomes permanently attached to the real property, but primarily benefits the business and not the real property. A couple of examples of that is business signage. So you might think, well, a sign that is attached to the side of my building, how can that not be real property? Well, that sign benefits your business, so it stays tangible. So it would be subject to sales tax when it is installed, no different than if you bought like a TV. They're similar, tangible. They're both tangible personal property. Data cabling, in certain instances, are still subject to the sales tax. There was the Newcomb case back in the early 90s that determined that data cabling was, in fact, tangible personal property. Special purpose lighting, there was a personal property tax case a while back called Oregon Ford, in which they found that the lighting that is in the car lots that oversee the light up the inventory of the cars, those were determined to be tangible personal property. So likewise, for the sales tax purposes, those lights themselves are still tangible, so they would be subject to the sales tax also when they are installed. Another area where you might see specialized purpose lighting is maybe in a grocery store where you've got in the fruits and vegetables sections, they like to have spotlights on those fruits and vegetables to make them look nice and shiny and really good to eat. So those are also tangible personal property, would be subject to the sales tax. Now, we're not talking about in that grocery store the lighting that is overhead that really is just providing the lighting to the entire store. That's not the lighting we're talking about. Same thing with a parking lot, the general parking lot of a grocery store or department store. That lighting is still real property. We have specialized heating, ventilating, and air conditioning equipment. So in like a data center, that air conditioning unit is generally hopped up or very specialized in order to cool all the computer equipment located in the data center. So those are stay tangible and will be subject to the sales tax. So what if a vendor or seller doesn't charge me tax? Well, sometimes when the sellers are located out of state, they're not required to charge Ohio sales tax, or you might even have an Ohio vendor that just for some reason doesn't want to comply, or they just don't know what they're selling is subject to the sales tax. Well, that's when use taxes becomes due on those items that are taxable, and companies can pay their use tax either on a consumer's use tax return, or if they have a direct pay account. Consumers' use tax accounts and direct pay accounts are both free. The state provides them free of charge. Direct pay accounts are generally for larger construction contract and manufacturing companies where when they purchase their materials or services there. At the time of purchase, it's not known if they're going to be used in a taxable manner. Individuals can also pay the use tax on their personal income tax return. I think we've had that for probably 10 or 15 years. One other form is the VPU, so it's a voluntary pay form, generally for usually when somebody makes 1 or 2 purchases and they didn't pay the tax on it, maybe larger purchases, they can just submit that on that voluntary pay form. Okay, test your knowledge. True or false? Purchases made over the internet are subject to sales and use tax to the same extent as purchases made in a brick and mortar store. Survey says true. Sometimes people may be caught up with the Internet Tax Freedom Act, and that doesn't have anything to do with the taxability of the goods or services being sold over the internet. That is only access to the internet. So those sales are still, as long as the purchases themselves, the items being bought, are actually taxable, then the use tax would also be due. Okay, what's the difference between a vendor and a seller? So we've got a couple of definitions here that are maybe a little less informal, but they get the point across. So we have a vendor. So a vendor is each person with a fixed place of business in Ohio from which taxable sales are made. So vendors must have 1 license for each fixed place of business. So the important note there is in Ohio and fixed place of business. So we have a couple of different vendors' licenses. We have a transient vendor's license, and that's generally for vendors that carry a stock of goods. They go to flea markets, things like that, or I think even in-state vendors of motor vehicle leases also are required to have a transient license. We also have what's called a county vendor's license, or maybe you might know of it as like a regular license, regular county license, and those are generally for those fixed place of businesses. They are $25. Both those licenses are $25. They can be obtained from us, or the county license can also be obtained from the county auditor's office. Next, we have the definition of a seller. The seller is a retailer located outside of Ohio who makes retail sales of property or services for storage use or consumption in Ohio. So that is the seller that doesn't have a fixed location in Ohio. They're located out of Ohio and they make sales into Ohio. Test your knowledge again. Joe has a small internet business and utilizes a marketplace to make additional sales. Joe makes the sales from his home office in Westerville, Ohio. What type of license should Joe obtain from the Department of Taxation? Well, he should get just a regular county vendor's license because he has that fixed location in Ohio. Time for our first code word. The code word is seller. Seller. Just to be clear, seller. Very good. Sellers, so when if an out-of-state seller has sufficient contact with the state, they are legally required to register, collect, or remit the use tax, the same as an Ohio vendor. So if they are legally required and they are out of state, then they generally get the seller's use tax account. Sellers without nexus with Ohio register generally voluntarily, and so they do that in order to provide a convenience or service to the customers so that they do not have to go out and put it on their Ohio income tax return or a voluntary pay, or use a voluntary pay form. So now what actually constitutes substantial nexus, Lori is going to discuss that.
So you're probably wondering why I was sitting next to Steve, so here it is. Complete Auto Transit versus Brady, it's actually not a substantial nexus case, but it is something that we can talk about and discuss, laying the groundwork for what tax is constitutional or how a tax is constitutional. Congress has the power to regulate this interstate commerce, and if they act on it, and there's a legal doctrine of a dormant commerce clause, and that exists to establish that states can act as long as they don't discriminate against interstate commerce. In Complete Auto Transit, the question was whether or not state tax violated that commerce clause, and it clearly provided the criteria for what becomes a valid tax under the under the Constitution. Complete Auto Transit was a Michigan company. They were doing business in Mississippi, and the court found that Mississippi tax was valid and the activity was substantially connected to that state. It was fairly apportioned, and it did not discriminate against interstate commerce, and it was fairly related to the services that were being provided by that state. So I'm going to skip over a lot of cases. There is a substantial amount of, pun intended, substantial amount of case law regarding nexus, but we're only going to talk about what people kind of focus on when we talk about substantial nexus for state taxation. And this is 1992 case called Quill Corporation versus North Dakota. In Quill, North Dakota had sought a declaration that the out-of-state seller was required to collect and remit the sales tax in North Dakota, the North Dakota use tax. Quill was a mail order business and had minimum contacts or minimum connections with North Dakota. The Supreme Court held that the mail order business did not need to have the physical presence in the state in order to permit the state to require them to collect and remit, but the physical presence was required for the business to have substantial nexus with the state of with the state of North Dakota, as required by the Commerce Clause. The court then discussed its reasoning in an earlier case called National Bellis Hess and the Department of Revenue versus Revenue of Illinois. It was decided in 1967. And in that case, the court held that the Illinois statute created an unconstitutional burden on interstate commerce and held that a seller whose only connections with its customers in the state was by a common carrier or mail order or mail, like a U.S. mail, that it lacked the requisite minimum contacts that were necessary. So the court in Quill had reaffirmed that physical presence discussion that they had had in National Bellis Hess, and it required that that was necessary in order to have substantial nexus. And that underlying issue was something that remained that way and relied on in these couple of cases for many, many years. And in that case, the court actually said, this is something for Congress to decide, and Congress is really better qualified to make that decision. So we're not going to take any more cases on substantial nexus and physical presence until 2018. So the court had laid this situation on the feet of Congress and said, it's for you to decide it. But when they didn't hear from them for 25 years, we saw a little bit of activity. There was a couple of federal legislations that were introduced, but they never really kind of brought them across the finish line. And so after 25 years, the court did decide to take another case. It was an interesting case because in 2016, South Dakota had established the statute that required sellers that had more than $100,000 in sales or 200 transactions into South Dakota, to collect and remit their sales tax. It was a no physical presence requirement and only this economic presence requirement. They had established this second bright line presence, bright line standard, similar to what was a bright line in the physical presence. And it acknowledged that the statute was going to be questioned or challenged by the former cases in Quill and National Bellis Hess. And they had actually initiated a declaratory judgment against these defendants to kind of prospectively look at this issue and kind of make that issue move forward. And in their statute, they specifically said by filing a declaratory judgment of the state operates kind of as an injunction, saying that the state cannot act on that statute until it's decided. And if you wanted to affirmatively come forward and voluntarily register under this statute, they would accept that, but they would not actively go out and enforce this statute at that point, once that declaratory judgment was filed. So the case was followed by lots of people, and it was questioned as to what it meant and why they were taking this case and why after 25 years are they making this decision. And it was decided in the end that the Supreme Court overruled Quill and National Bellis Hess. They said that language that we had created in those standards that we created in those two cases should be overruled. And that South Dakota standard was sufficient because the seller availed itself of the substantial privilege of carrying on business in South Dakota. A couple of the items that the court looked to justify or to acknowledge what was going on in South Dakota was that they had a safe harbor for those smaller businesses under 100,000. They had no retroactivity, again, kind of touching on that statement that they had made, filing an injunction sort of against themselves, and that they were a member of the Streamlined Sales and Use Tax Project. We're going to talk a little bit further about the Streamlined Sales and Use Tax project a little bit later on. Steve's going to touch on that, but something important because Ohio is also a member of that. We're going to talk about now what is our standard in Ohio. We have 2 information releases on our website, tax.ohio.gov, talking about this issue. It's also established in the statute in 574101H and I. And I'm going to go into each of the provisions that is discussed in there. It can be a little lengthy, but I promise I'll give it back to Steve, and he will talk to you again. One of the provisions is that you use an office, a distribution facility, or a warehouse, something similar to that, operated by the seller or anybody else, maybe somebody's acting as their agent in that capacity in Ohio. The only thing that's not kind of covered by this would be somebody that's operating as a common carrier. So if you're hired to store your goods and services in the state, you hire a third party to do that, that's one thing. However, if you have a common carrier that you hire in another state, and they just happen to have a warehouse in Ohio, you didn't hire them to hold the property in Ohio, however, it just was passing through Ohio, that common carrier scenario would not give you nexus, but the latter would. The next prong of it is whether or not you regularly use an employee, an agent, a representative, a solicitor, an installer, a repair person, somebody acting in those kind of capacities for conducting your business or moving your business forward, engaging in something in a similar industry or classification, something that has a similar product line, maybe a company that you're closely related to that has exactly kind of same products, use of a trademark or service marks, trade names, again, doesn't have to be completely interconnected kind of companies, but could be utilizing the licensing of those trade names to each other, and again, kind of in a company that's acting together. Those kind of things will give you substantial nexus in Ohio. The next one is the use of someone, again, other than a common carrier that's doing any of these activities. So if they're receiving your orders or processing your orders, if they're using that person's employees and facilities in the state to advertise or promote your business, those could also give you substantial nexus. Whether you're delivering, installing, assembling, performing maintenance services, all in connection with that customer. If you're having somebody do that activity for you, even if you're located out of state, that gives you substantial nexus in the state. When you're facilitating the delivery of tangible personal property in the state, or you're having them pick up property at somebody else's office, distribution facility, even if it's in a not a interconnected company, but you're having them pick it up at that warehouse, that could give you substantial nexus if it's kind of contractually related. So now we're going to pause for a test your knowledge, just kind of covering those first couple that we've talked about. Again, just trying to break it down a little bit. Company A sells prefabricated furniture that's required to be assembled. Company A has absolutely no physical presence in Ohio, but they do hire a third party that is well versed in their product to perform the assembly of the product. The customers can purchase this third party to assemble the furniture through Company A or the third party's assemblies of Company A's product. They can go to the third party themselves. Does Company A have nexus? And the answer is yes, because the third party is in this state and they perform that service on behalf of the seller's, or for the seller's company on behalf of Company A, for the seller's customer on behalf of Company A, they now have nexus with Ohio.
It's easy for you to
Yeah.
say.
The next prong we're going to talk about is whether or not they make regular deliveries of the tangible personal property in this state. So again, not a common carrier scenario, but a private carrier that you've hired to physically deliver the property into the state. They could act as your agent with those trucks, and that would give them substantial nexus with Ohio. You could have an affiliated person, and that could give you substantial nexus in Ohio. So if you have an entity that you own at greater than 50%, that could be an affiliated person, and they could give you substantial nexus with the state of Ohio as long as they are moving your business, actively taking steps in your business, those kind of things. If you own tangible personal property that's rented or leased to somebody in the state, then, or you offer that tangible personal property for approval to consumers in the state, one of the things could be that you lease property, so you have motor vehicles that you own and you lease to individual consumers. Those would be a scenario that would give you substantial nexus. You could also have free samples that you let somebody utilize for a period of 30 days. Those samples you then have to send back to the company when you decide that you don't want it, or if you do want it. Those would give you substantial nexus in the state. Another long one is when you enter into an agreement for a commission that kind of refers potential customers to a seller, and you provided that you are doing this, you can do it on the website, you can do it in a presentation, you can do it in telemarketing, all of those types of activities, as long as those gross receipts in a 12-month rolling period exceed $10,000. So those could be activities that somebody's doing in the state of Ohio, and they would give somebody that's outside the state that's paying that has $10,000 in gross receipts in 12 months, gives them substantial nexus with Ohio. And that last provision has actually been in place in Ohio since 2015. Another situation is when you use in-state software to sell or lease tangible personal property or services to consumers, provided that you have gross receipts in excess of $500,000 in the current or preceding calendar year. So the last one was based on a rolling 12-month statute. This one is based on a previous calendar year or current calendar year of gross receipts in Ohio. And again, kind of that secondary piece of using the in-state software.
The $500,000 has to be in this state, right?
Correct.
Okay.
$500,000 of taxable sales inside the state of Ohio.
Sorry.
Nope, it's okay. And this just provides a definition of what in-state software is. It means that it's computer software as defined in 5739 of the revised code that's stored in the state. And again, it's kind of coding and JavaScript, those kind of things. It's not necessarily related to cookies. So some people might call these cookie nexus. It's not necessarily what we're talking about here. What we're talking about is actual coding application software that is connected to your market. Those kind of things would give you this substantial nexus. This is the first provision that is one of the newer provisions. This came into play in January 1st of 2018. And this one, along with the second provision I'm going to talk about, are part of a pending case. So I'm not going to go into too much detail about them, just kind of mentioning them, but they were challenged against the department. So I'm going to take a step back right now and talk about testing your knowledge. So a large out-of-state seller, Seller A, sells retail clothing to individual consumers through a website. They also provide the clothing in a catalog application that can be downloaded onto the customer's computer or cell phone. The catalog application is considered software. It is the HTML and JavaScript coding that is displayed in the seller's website to the consumer's computer or cell phone. In 2017, Seller A had $4 million in gross receipts throughout the United States and Canada, and $300,000 of those gross receipts were related to sales of the clothing to consumers in Ohio. Does Seller A have nexus? So the presence of the software that we talked about that's owned by Seller A and it's in Ohio is significantly associated with Seller A's ability to establish and maintain their marketplace. And that is that physical presence standard that we had seen in Quill. However, Seller A doesn't have substantial nexus with Ohio because they don't meet the requisite sales threshold of the $500,000. And again, the facts were that they had $300,000 in gross receipts in Ohio. So in that situation, Seller A would not be required to collect and remit the tax. However, they can voluntarily register with the seller's use tax account and collect and remit on behalf of those customers that bought $300,000 worth of goods in Ohio. And the final piece to the substantial nexus that began in January 1 of 2018 is whether or not somebody provides an agreement with another person for a content distribution network in this state. And that content distribution network kind of accelerates and enhances the delivery of the seller's website to consumers, provided that the seller has gross receipts in excess of $500,000. We sort of saw that in the last one. in the current or preceding calendar year of tangible personal property that's realized, or the services that are realized in the state. A content distribution or content delivery network is a system of distributed servers that deliver websites to one web content to a user based in a geographic location. That sounds really complicated, but you just have a lot of different servers in various different locations. You've hired somebody that places those servers close to where your marketplace is, and that establishes a better web platform for your customer. Those would give you substantial nexus. In Ohio, again, prerequisite on that, $500,000 in gross receipts in a current or previous calendar year. So now I'm kind of moving out of that realm, and we're going to kind of switch to the opposite side of this. So we've talked a lot about Ohio. So what does it mean for people that are located in Ohio that are going to be selling to other states? So if you are making internet sales and you're located in Ohio, you have that fixed place of business that we talked about before, and you're not just selling to Ohio consumers, you're selling to the intrastate consumers, but you're also selling outside of the state. So one thing to keep in mind is that just because you're selling over the internet, you are physically located in Ohio. You do have a requirement to collect and remit in Ohio. You would charge the tax rate for intrastate sales. You would charge a tax rate that's collected where the order is received by the vendor if it's a tangible personal property. And services are taxed where the service is provided. So that's just something to kind of consider about intrastate sales. It is going to be different with sales outside the state. And that it becomes whether or not you're actually responsible for collection and remitting to locations outside of Ohio. So when you're selling from a fixed location in Ohio and you're selling it to a destination outside of Ohio, it's actually cited or sourced to that location outside of Ohio based on our statutes. So it could be that other state that you're going to have to look to determine whether or not it's subject to tax. So something to consider is, what is those other states' nexus laws? We've talked a lot about what Ohio's nexus laws are, but we are not going to spend too much time on trying to spell out all the other states' tax laws. I think it's important for you to reach out to those other states. We're going to give you a couple of resources to talk to those other states in a moment. But what are those other states' nexus laws? Do you have a responsibility to collect or remit in those other states? And something else to consider is, just because it's taxable in Ohio or not taxable in Ohio doesn't necessarily mean that that's what's the answer in the other state. It could be that they have an exemption for the item that you're selling, or it could be that it is the exact same product line and maybe it is not taxable. So the economic presence standards have come into existence in a lot of different states. There are many that have them right now. I'm only going to touch on a few of them. I think it's important to, again, stress that these provisions that we're talking about over the next few slides, we are not experts in their statutes. It's important for you to reach out to those other states for their interpretation on these statutes. So Kentucky was one that had a statute that came into existence on July 1, 2018, but they said that they are not going to enforce it until October 1st, 2018. They had the economic thresholds. Did I skip over?
No, I think it's the next one.
Yeah, sorry. They have an economic threshold similar to the South Dakota statute, 200 and more sales in Kentucky, $100,000 in gross receipts. And this is related on the previous or current calendar year. Michigan also has economic thresholds. Michigan sales are based on sales into Michigan of $100,000 or the 200 transactions, again similar, based on the previous calendar year only. So again, Kentucky was previous and current. This one is just based on the previous calendar year. It had a start date of September 30th, 2018. Utah was a January 1, 2019 start date. They also had economic thresholds that were recently put into their statute. You have to meet one of the two thresholds. Again, $100,000 or 200 transactions. Just very similar kind of standards, but again, each one may have nuances. Certainly reach out to those states. What I want to point out here is those three states that I just mentioned Kentucky, Michigan, and Utah are all streamlined states, similar to Ohio. And again, we're going to talk about why that's important in a moment. Colorado had, this is actually a typo, it's not March 1st, 2018, it's March 1st, 2019. They originally had a date of December 1st, 2018 to create their economic threshold standard, but they have pushed that back. They made an announcement that they're pushing it back to March 1st of 2019. Again, $100,000, 200 transactions based on a previous calendar year, and Colorado is not a streamlined state. One of the best resources to find out streamlined states as well as some other states could go to the Streamline website. So streamlinesalestax.org is a good resource to connect you to those other states. They have a website that actually lists out the contact information, phone number, websites, and whether or not they're a streamlined state. The online taxability matrix is important for streamlined states. Each year, Ohio fills out a taxability matrix and a certificate of compliance, and it lists out certain uniform definitions and how we treat those uniform definitions. We certify this each year. It goes out on the Streamline's website, and each state that's a member of Streamline will fill out the same taxability matrix. So you can see how uniform definitions match up in other states, and sometimes how those exemptions apply. It just depends on how they list them out on their in their comment section, but it's definitely a really good resource to know how most tangible personal property, some sort of uniform tangible personal property, is treated in these streamlined states. Steve.
All right. Before I go into Streamline, I realized I wanted to discuss a little bit more some of the services that are taxable. I mentioned that there are 20 to 25 taxable services, and the presentation really only kind of went over those that are kind of important to maybe the internet environment, but there are certainly other services that are worthy of discussion. Landscaping and lawn care services, and these are items that you'll see on audit. We'll see, you as a homeowner may have your somebody come out and mow your yard, landscape your yard, put trees and bushes in. Those items are subject to Ohio sales tax as long as they meet a $5,000 minimum sales provision. So landscaping and lawn care, along with building maintenance and janitorial service and snow removal services, also have this $5,000 minimum sales provision.
So that's kind of related to, so if you have a neighborhood child mow your lawn for you, that would not be a taxable lawn care service, because they're probably not selling $5,000.
Unless Jimmy's pretty busy.
Yeah, and they're probably not selling $5,000 worth of sales. However, large corporations that bring the trucks in and the big lawnmowers, those would be the likely.
They're the likely candidates, right? So getting into building maintenance and janitorial service. So this is also for the cleaning the exterior or interior of a building and any tangible personal property located therein. And again, we noted that is subject to the $5,000 minimum sales provision. Snow removal services by mechanized means. So that again kind of gets into the neighborhood kid using a shovel, that they are not, that's not going towards even towards the $5,000 if they're not using mechanized means. So if they have a snow blower, that would be mechanized. So then they'd have to get their $5,000. One of the things too to note there is that so you usually landscapers and will in the winter, their job is snow removal. So those two $5,000 are separate. They're separate, distinct $5,000 thresholds that have to be passed. Motor vehicle towing of wrecked or disabled vehicles, that's another taxable service. Exterminating services, employment placement services, where maybe a company goes to a service provider and says, I need 3 of these types of employees, and that company goes out and finds 3 candidates for them. Or maybe as the individual going to the service provider to say, hey, I need a job and I can do this. And then that company helps them find a position. So, and then employment services. I'm not going to touch too much on employment services because it's rather complex, but employment services comes up a lot on audits. generally in the manufacturing and IT areas. We recently had some court case decisions come down here in the last year or so. So that's still an important, busy subject on audit. Okay, now to Streamline. So Streamline began back in March of 2000, so it's been almost 19, 20 years now. It's hard to imagine that it's been that long. The purpose of the agreement is to simplify and modernize sales and use tax administration in order to substantially reduce the burden of tax compliance. So that was kind of one of the topics, I think Laura said, maybe in National Bellis Hess, that the burden of tax compliance was pondered by the courts, and so Streamline came together, and that is one of their things that they wanted to kind of help overcome. Ohio became a full member on January 1st of 2014. There are currently 24 states that are full members and one associate member, which is Tennessee. I think Ohio was probably the last associate member. I think there was it was Ohio and Tennessee were associate members for a very long time. And then, like I said, there in 2014, Ohio became a full member. Okay. The agreement focuses on improving sales and use tax administration systems for all sellers and for all types of commerce through all of the following. So state level administration of sales and use tax collections. That means that you're not going to have a company having to submit sales tax to multiple jurisdictions within a state. Single jurisdiction. You send it to the state, maybe the state sends it out to the locals. Uniformity in state and local tax bases. That is for so that in Ohio you have counties, so they don't want one county taxing something and another county not taxing it. That makes it very complex for collection of the tax. Uniformity of major tax-based definitions. I think Laura touched a little bit on that. The definitions are the same, or they're defined in Streamline, and the states subsequently adopt those definitions. Now, Streamline doesn't say you have to tax or you have to exempt those transactions that are based on the definitions, but they do make you adopt essentially the definitions so that the definitions are uniform across the Streamline states at least. Central electronic registration system for all member states. I'll discuss that in just a little bit. Simplification of state and local tax rates. Now, that's a very difficult challenge. You've got, I think there's one state close to us that has one single rate across the state, and then there are literally other states that have dozens, if not hundreds, of different tax rates. They've got decimal points that go out 3 places in their tax rate. So you could have a tax rate of 5.637, things like that. So that's very, very complex tax rate schedules, I guess. Uniform sourcing rules for all taxable transactions. Streamline is definitely a destination sourcing. Yeah, they're very focused on destination sourcing. In Ohio, here probably, I think it was back in 2010, we changed our sourcing provisions to for intrastate sales to be sourced to the location where the order is received. Well, that kind of went against Streamline. Streamline did allow changes to the Streamline agreement to allow for Ohio to source those intrastate sales basically by origin.
As long as the out-of-state sales remain destination.
Oh, great, very good. Simplified administration of exemptions, and that comes across in a couple ways in terms of allowances and thresholds. So some states might have clothing that above $100 is taxable. If it's below $100, it's not subject to their state's tax. Also in that area, you have exemption certificates, in that Ohio here a couple years back went to fully completed. So if you receive a fully completed exemption certificate within 90 days, the vendor was essentially provided relief of liability for those sales. Well, before that we had good faith, properly completed, a properly completed exemption certificate which relied on good faith. And so that kind of put the vendor in a tough spot. The vendor had to kind of police these exemption certificates, or else on audit they might get hit for liability. even though they were doing the best they could. Now, when you get into companies going across many states, you run into problems where, hey, they may not have the expertise of all the states that they're in to be able to know the exemption, the applicable exemptions that are available to each state. So that I think they've come a long way, and really, I guess I have to agree that allowing the vendors to get relief when they get a fully completed exemption certificate, I'm all for that. It really helps those vendors come up with the right answer, I guess I'd like to say. Simplified tax returns, we've got basically one return. It's called a simplified electronic return. It's known as an SER. It can be filed with all the states. You file one return with all the states.
Streamlined states.
Streamlined states, sorry. Simplification of tax remittances, so they can provide through electronic transfer of money, as well as the SER has use tax on it, so you can remit your use tax for that state. Very importantly, the protection of the consumer's privacy. That's very important for the entire system to be relied on. Something else to think here. So we're talking about streamline, and this is where Ohio vendors are maybe most likely to be sellers in other states. Laura also touched on this, that this might be something that you need to think about if you're an Ohio vendor and you're selling outside Ohio. It might be it's a little more complex now. So the streamline, so the company can use what's called a certified sales tax administration system. It's they're called a Model 2 seller. Streamline uses this Model 2 model language. So a Model 1 seller is a certified service provider. I'll discuss that on the next slide. Model 3 is where basically the company can go out and create their own software, and then they file and register their own taxes. And then there's a Model 4 seller, which is basically all the rest. There are currently no Model 2 and Model 3 sellers, so that's how popular that option is. And so basically Model 4 and Model 1s. Like I said, there's that centralized registration system. They can obtain one account number, ID number, that they use in all the states to file their returns. They still have to file separate returns in all the states, but it's on that simplified electronic return, so it's very standardized. And once you register, you have to register with all the member states, as long as you're making sales into them. And then you must collect and remit the sales taxes on all the taxable sales in those states. A CSP is certified by the Streamline governing board, and they have contracts with the Streamline in order to perform basically all the functions of the seller. There are currently 7 certified service providers. Streamline basically goes into a review of the companies that come forward, both when they first come in and then every 2 or 3 years they are reviewed. One of the things they look at, make sure they're financially stable, make sure they have good checks and balances, they've got reliable data security, and that their hardware is secure also. The CSP will work to identify which products and services are taxable. They will help the company to place their product into buckets of taxable or exempt. And the states even work with the CSPs. CSPs can request that those transactions are certified by the states as taxable or exempt. So if a transaction falls into an exempt bucket and then later on audit, the state determines that it was a taxable transaction, then the certified service provider would be given liability relief. Again, the appropriate tax rates, so rates and boundaries, the tax CSP creates has a database that is also certified by the states. Again, liability relief if there is something incorrect. And again, they maintain a record of the transaction. Those transactions are then audited also every 2 or 3 years by what's called the audit core team of the Streamline sales tax project. And they actually go out and kind of do a review of the data of those records, those sales records, to make sure they are gathering all the required information, the rates and boundaries, the address, the exemption certificate information. CSP set up and integrate the CSP's software with the seller system, prepare and file the tax returns. They remit to the tax to the streamlined member states, and they actually will even resolve any notices that the states send them or audits by the streamlined member states. Actually, in most states and in Ohio, the CSP actually is the taxpayer. So if we choose to audit the CSP, or we could audit one of the CSP's customers, we would issue the any assessment into the name of the CSP, and then it'd be up to the CSP to get the money back from their client through their contractual relationships they have with them. Like I said there, I started to say about the rates and boundaries. So each of the streamlined states then certify the rates and boundaries to the CSP, and that kind of, again, gives them that liability coverage that these are good rates and good boundaries. CSPs have always done a very good job of that. Their data is very good on getting rates and boundaries generally. Streamlined member states, did you want to say something?
I just wanted to say that I don't think we focus on it as much, but something that's kind of, because of the Wayfair decision, this is a little bit in flux, but it's still a really good resource. One of the things that we talked about was requiring the CSP or the individual to register in all the full member states. That may not always be the situation, especially with the difference of economic thresholds. You may get to now pick and choose. It's something that the governing board is discussing right now.
They're pondering now, right?
Yeah.
Okay.
So you may get to not have to require to register in all of the full member states.
Right. The final thing there, the streamline, the CSPs are compensated by the actual member states. So the CSPs have a threshold that they are compensated for. So for X amount of sales, they are up to X amount of sales, they are compensated at, say, 8%. And then as they increase their sales, taxable sales, and their sales tax, their compensation, that percentage goes down. I think it goes all the way down to 1%. But the CSP does not get the additional discount, the 3/4%. They don't get the discount. They get their compensation. The company does not get the discount either. So.
Yeah, and it's only for volunteer sellers.
Volunteer sellers.
If you're physically located in the state, you don't necessarily get that benefit, but
right.
It is something to take into consideration when selling to those other states.
Very good. Turn it over to Laura for one. Oh, I'll do the code word. Code word, service. The final code word is service.
Okay. So the last kind of section of this is going to be related to federal legislation and kind of Ohio's response to what happened in the Wayfair decision. Should be a pretty short section. We're almost to the end of time too. If you have any questions that you're thinking about, feel free to put those in so we can answer some questions here in a few minutes. One of the provisions that we saw be introduced based on the physical presence standard and having asked Congress to act was the Marketplace Fairness Act. This started to come around in early 2010s, I would say, 2011, 12.
It's been pondered for several years.
Yeah, it's been pondered for a while. And the last time we saw it was most recently in April of 2017, well before, almost a year before the decision in Wayfair. And one of the characteristics, or some of the major characteristics of this, is that you could be a member of Streamlined Sales and Use Tax Agreement, and then if you had that base or that understanding, if you're a full member, then you could require all sellers to collect and remit use taxes. There was a prohibition against it starting between October 1st and December 31st. If you were not a member of SUTA, you had to meet certain minimum qualifications in order to be able to implement the collection and remittance requirements, and also defined what a remote sale was. And it really was a seller who was not legally required to pay, collect, remit the local sales tax unless they were provided underneath this bill. The next one was the Remote Transactions Parity Act. This was most recently introduced again in April of 2017. It was originally introduced by Representative Shevitz in 2015. In 2017, it was introduced, although the representative on it, Shevitz did co-sponsor it. Christy Nome was the sponsor in 2017. It looked similar to some of the major characteristics that we saw in the last bill. It provides similar authority, provided audit protections for small businesses. It had a phase-in for small businesses. Started with 10 million in gross receipts all the way down to 1 million, and then that you didn't have that phase-in at all. So over a period of about 5 years. It required states to give free access to the software, similar to what we talked about before with the certified service providers, and to assist in collecting and remitting the taxes. And the last one I'm going to talk about, there were a couple of different bills, but the last one I'm going to talk about is the No Regulation Without Representation Act. It's the concept of keeping quill. This was recently introduced in June of 2017. The bill prohibited states from taxing or regulating a person's activity in interstate commerce unless the person was physically present in that state, and then defined physically present as holding employees and agents, and a lot of the physical connections with Ohio, physical connections with the state, similar to the first couple of provisions that we talked about, maintaining a warehouse in Ohio or maintaining a warehouse in that state, things like that.
Do you recall, Laura, there was a introduction of a federal legislation in which they wanted to make basically...
This is on the cuff. I have no idea what he's going to ask me.
There was a law introduced where it was origin sourcing of the sales. So you could be in California, and whatever's taxable in California, they ship it to Ohio. You're going to be taxed in Ohio on whatever's taxable in California. And just the whole concept of that, and it was just really not that very complex, not a very good idea, I guess. And
it was proposed. I can't remember.
It did not go very far.
I don't think so.
Okay.
I can't remember the exact name of that bill, but those were not the provisions in the first two that we talked about. So the Marketplace Fairness or the Remote Transaction Parity Act.
Yeah, I knew it was
those were destination source concepts, not necessarily what he had just discussed, but that other federal legislation was proposed at some time. I can't remember exactly when. And the last thing that we're going to talk about is what happened since the decision in Wayfair, June 21st, 2018. And we feel that the decision did not have immediate impact on Ohio. Ohio's laws do need to change to that economic standard, that 200 transaction, $100,000. We need to have a statutory change in order for us to make that ovation that out-of-state sellers are required to collect or remit in Ohio under those specific standards. We did provide all of those factors that we talked about regarding the connections with Ohio, the physical presence, and the $500,000. Those kind of activities are still required under current law and not necessarily related to that decision. We have not seen any current movement from the Ohio General Assembly on Wayfair. Possibly we'll see something in the future. Have nothing to report at this time. So I think, do we have any questions? Okay.
The first one, if a company buys a piece of equipment from an employee or individual, and that piece of equipment, is that piece of equipment subject to sales or use tax? Generally, that's kind of a generally no. I would say most likely it's a casual sale as long as it was subject to a taxing jurisdiction.
And they purchased it for their own personal use beforehand, so they would have paid sales tax on it maybe when they bought it originally. At that point, it becomes a casual sale, a kind of like a garage sale. I just got rid of my product. It does change if you are a broker of some sort, or if you are in the business of also selling that type of similar equipment.
Very good. I was saying, so if you're a computer company that's going out of business and you're getting rid of some of your inventory, then that's obviously not a casual sale.
Yeah. So good question. We'll do one more. I believe we have time for. Would a company that charges a subscription fee to access data via the web interface and/or app be subject to sales tax, and would that be based on the customer's location? So yes, this subscription fee, just a generic understanding of the question here. Generally, the subscription fee would be taxable as electronic information services if it's going to be provided for business use. So individual consumers, individual people in their homes that purchase that type of subscription fee would not necessarily be subject to electronic information services as a service. But it is something, so it's only used in business. And so I guess at that point, then it would be based on where the customer's utilizing that service. So the situsing is not necessarily based on destination. It could be maybe used at a different office location. It could be in
Where
a
the
different,
benefit of the services.
wherever that benefit of the service is being received. So, okay.
Thanks, Nate.
Thanks for paying attention and for being here this afternoon. And we're going to turn it back over to Leah.
Thank you. We hope you enjoyed the information provided today. I do have a few announcements that I would like to go over. The next OVTA will be Wednesday, February 20th, 2019. Please visit our OVTA webpage at tax.ohio.gov, as this is the #1 communication source for all OVTA information. We will continue to work with different boards, chambers, and commissions to get that information out to you, along with tax alerts. The second announcement has to do with code words. For those of you wishing to receive CLE and CPE credits, you will be required to submit the code words through a post-webinar survey. The survey will display once you exit the webinar. If for some reason it doesn't display, you will receive an email with a link later on today, and you can submit the survey at that time. The last announcement has to do with evaluations. There will be a link for the evaluations in the email that I mentioned a moment ago, and you can submit the evaluation. We do ask that you submit an evaluation, as it allows us to work on areas of improvement, and we try to incorporate your feedback to make this an overall better viewing experience. This concludes today's OVTA. Thank you for joining us today, and we hope you have a great day.